Parenting time. This hearing is being conducted via Zoom. Present is Attorney Jason Meritt, representing plaintiff mother Lauren Jenkins. Ms. Jenkins appears to be present. In addition, Attorney William Godfrey is present, representing defendant father Gregory Adair. Mr. Adair is present. In addition, the guardian litem for the minor child, Leah Work, is also present. Good morning, everyone.
Morning, Judge.
Morning, Judge.
The parties have conferred at length this morning with Ms. Pratt, who has provided the court fine recommendation that parenting time shall continue per the current court order, which is week on, week off. Catherine Scott for the front of the court shall interview the minor child Colton. The child's preference will be provided to the court after 3 p.m. on a school day. Mr. Attorney Kazmarik's motion to withdraw as attorney of record, which I didn't know was before the court, is being withdrawn. The minor child shall attend counseling and parents shall follow all reasonable recommendations of the counselor. Finally, that this matter be continued to review parenting time February 14th, 2024 at 8:30 a.m. via Zoom. That is recommendation. Mr. Kazmarik's is recommendation to be with your client.
Yes.
And Mr. Godfrey's is recommendation to be with your client this morning.
Yes, Judge.
Ms. Rorka, do you believe this recommendation to be in the best interest of the minor child at this point in time?
At this point in time, Your Honor, yes.
Court's always reluctant to put a child in the spotlight. This child is 13 years old. Do we really need to go there, Ms. Jenkins, Mr. Adair, to have this child interviewed by a third party? The last thing Colton wants to do is be interviewed by a third party.
That's exactly what it was.
The mother wants it, Judge, and father does not. Father believes that the counseling would be sufficient.
Mr. Kazmarek?
That's exactly what Colton's been asking for, and Ms. Rorka she was had plenty of conversations with Colton asking for the same thing. Can speak to that as well.
That is correct, Your Honor. I've had multiple conversations with Colton. I think it's important that Colton feel that he has an opportunity to be heard. And I think it's important that he have that and continue the counseling and following recommendations of the counselor.
Well, absolutely. You benefit from counseling that will continue. How many people are we going to have Colton be interviewed by? After, obviously, Ms. Rorka, you've talked to him about preference and what's going on. Now we have Ms. Scott going to do it, then the court's going to do it. How many people are going to interview Colton? Is it necessary, Ms. Rorka? I mean, you've talked to, have you shared your Colton's thoughts with the parties, the parents?
Yes, Your Honor, I have, and I've had multiple conversations with Colton, and he has asked to have the opportunity to have his voice heard. I understand he's only 13, but at the same time, he is 13, and he's old enough to have opinions. He's lived with his parents for his entire life, and I think that it's important that he have that opportunity.
Well, he has had his voice had to be heard through you, has he not?
Theoretically, but given the circumstances and where things are at, he doesn't feel that he has been. To put this child through continual interviews, where do we stop? Let the trial court do it afterwards? So do we, what purpose? I'm of course not convinced there's a purpose served by this. We've got a guardian litem in this case.
Well, Judge, I mean, if Judge Court to hear arguments, I mean, I think the child feels a lot of anxiety and discomfort going to dad's a lot, which has been expressed by Ms. Rorka. I think the reduced parenting time schedule for dad is what we're asking for, what Ms. Rorka would think was appropriate. Ms. LaPrade felt differently. And again, I think Colton wants to be heard, needs to be heard. And I don't think he feels like he is being heard. Because nothing's been changing yet. So that's the reason that we thought that Ms. Rorka might be Ms. Scott would be a good additional piece on top of the counselor and Ms. Rorka to get to the court's attention.
Have the parents talked with the counselor?
I have.
Yes.
My client has briefly, Judge. It's a situation where the counselor has not integrated the family, the mother and the father and the child. And that, I think, is ultimately the goal of the counselor, as near as I can figure. We just got a undated letter today, emailed, 3 sentences long, from the counselor.
There's no questions. Mr. Adair, Dad, you need to nurture this relationship with your son. He's a young man now, 13 years old.
And Judge, my client is involved in his basketball. He is now got a major role in a play at the school. He had been in band. There's a lot of things that my client does, and the difficulty my client has is there's different rules at his house. My client has a 1 hour limitation on social media, the screen time. At mom's house, child reports he is on it for up to 2 o'clock in the morning on the screen time. So I think the child is of course going to say, boy, I like the screen time and I want to be at mom's house and not at dad's house because I can be in the screen time without limitation at mom's house.
Justifying truancy.
And I mean, last Wednesday, Judge, the client, the mother didn't have him go to school on Wednesday. I mean, there was no reason not to have them go to school other than mother saying it was only a half day and they were going to watch videos. So, I mean, there's a difference in managing a household. If the school was in session, the child should go on. That's what dad's belief is. Mom didn't think that it was necessary for the child to go to school on Wednesday.
Absolutely. This child needs to be going to school. Mr. Meritt, is it true your client did not take the child to school on Wednesday?
The child didn't go to school the day before Thanksgiving.
Why?
Day before Thanksgiving, it was Thanksgiving break.
Mr. Kazmarek, why did he not go to school? Was he out of town?
No.
He needs to go to school every day.
Right.
It doesn't matter whether it's a 2 hour session or half day or full day. If he's not going to school, you need to take him to the emergency room. Okay, I guess the court needs to perhaps raise this child. What about the allegation that he's got unlimited social media time, Mr. Kazmarek, at mom's house?
That's untrue.
Okay, does she pose what kind of limits does she impose on that?
He goes to bed at 9 o'clock. He does his homework every day. He doesn't get on his phone or anything until he's done with his homework.
Okay, well, does social media get turned off at 9 o'clock when he goes to bed?
Absolutely.
Jenkins?
Yep, I even take his phone.
All right. The court is not pleased that Miss Jenkins is not taking his child to school. That is inappropriate. This child needs to go to school every day. Do we need to modify parenting time? Miss Jenkins, if you're sick, you came to school, you need to call dad that morning.
Yep, I would have took him.
No.
It's simply unexcusable. This court will not tolerate letting a child to say, well, I don't feel like going to school today. Please want to go to school? I got a sore throat. You take it to the emergency room. Ms. LaPrade, in the light of the court's concerns about the child being interviewed after Ms. Scott, then they're going to want to interview by the court. What's your thoughts? Do you think there's a benefit to him being interviewed by Ms. Scott? What does that benefit the child?
Your Honor, after speaking with Ms. Rurka as the LGAL, I believe that she feels, and I somewhat agree, that him being interviewed in this building may give him a sense that he's being heard. We all know that that's only one of the factors, but I think for his own self, he's dealing with a counselor, there's other things going on, but for his self, coming into this building and being able to talk to a neutral third party may give him the feeling like somebody's listening. And I think that's the only reason that I did agree with that, and allowing that Ms. Scott sit down with him so that he feels that somebody is paying attention. And unfortunately, Your Honor, I have the same concern you did regarding the school, which is why I did not modify any parenting time at this point. But more so, Colton's peace of mind was to come into the building, basically.
All right, thank you, Mr. Brad. And if that gives Colton some sense of being heard, is it anticipated this report will be shared with both parties?
No, sir, just you. That's why it says the report will be given to the court.
Okay.
Child preference interviews are only for the court.
Okay, so Ms. Scott will reach out to the parties to coordinate that date and time for the interview. Is that correct?
Yes, sir.
All right, so the Anything further, Mr. Kazmarek or Mr. Godfrey?
No, Judge.
No, thank
All
you.
right. The court will adopt the recommendation. Mr. Wright, you had a sense that the parents are ordered to take the child to school when school is in session.
Yes, sir.
If the child taken to school, you need to take the child to the emergency room. Do you understand that, Ms. Jenkins?
Yes,
If you fail to do so, the court's going to hold you in contempt of court. Mr. Dare, this applies to you as well. If it's on your time and the Colton's not going to school, you need to take him to the emergency room. Or they get him to the doctors that day. If the doctor can't see him that day, you need to go to the emergency room. He needs to go to school.
My client understands. Absolutely, Judge.
The court will order that. We just had one sentence in here, Ms. LaPrade.
Yes, sir.
All right, the court will adopt the recommendation. We'll put this back on our docket, February 14th at 8:30. All right, that'll conclude this matter. Ms. Maros, before the court,
Thank you, Judge.
as a result of this court entering the ex parte order on November 17th, 2023, which suspended the defendant father's overnight parenting time and granting extended parenting time to the plaintiff mother of the 8-year-old child of the parties. This hearing is being conducted via Zoom. President Attorney Michael Spiros representing the plaintiff mother, Anna Maria. Good morning, Mr. Spiros.
Morning, Your Honor.
It appears that Andrew Sabota has not appeared. This matter was scheduled for 9 a.m. It's now 9:40 a.m. Mr. Sabota has not contacted the court. Mr. Spiros, has Mr. Sabota contacted your office or your client at all?
He is not, and the record should indicate that my client tried to call him this morning, and the call went directly to voicemail, and I think the voicemail was full. And she sent him a text message, and he's not responded to either.
The minor child is now currently in the possession of mother. Is that correct?
Yes,
Okay. And of course, the prior parenting time order of 2019 was week on, week off parenting time. The recommendation this morning of the Ms. Barr from front of the court is that the ex parte order of November 17th continue, namely, father shall not have the overnight parenting time, and further that the father is not permitted to remove the minor child from school, and that the mother's child support obligation shall be evaded as of December 1st, 2023. That is the recommendation, Mr. Spiros. Is this
We agree with
recommendation
that,
be with
Your
your client this morning?
we've consulted, and we agree with the recommendation in front of the court.
How do the parties currently facilitate the exchange of the minor child, since dad cannot pick up the child from school?
They live near each other, and my client can provide transportation. And we've spoken, and with the existence of the order in mind, it is still her intention to provide him with parenting time.
Does your client believe that Mr. Sabota will comply with the court order in terms of returning the child at the end of the day?
Well, that's what we're concerned about. And we may have to fashion the parenting time such that he doesn't have the opportunity to not comply.
Well, first of all, even though there's no proof of service in the court file, the court has received a Monroe County Sheriff's Office report dated November 25 from Deputy Brian Richuba, as well as supplemental report by Deputy Brian Bajaskis. They've indicated that they have they've called Mr. Sabota at his 409 area code, left voicemail messages. They have gone to an apartment known as 4102. Is that where Mr. Sabota lives?
Yes,
Okay, is that where where mom takes the child to dad for parenting time?
yes,
Right. And is that Lambertville, Temperance?
that's in Toledo.
Toledo? Okay. The report's not indicate, but the deputies made numerous efforts to contact Mr. Sabota. The report also indicates, and perhaps you can verify this, that Mr. Sabota picked up minor child from school on November 21st and did not bring her home. There was a text communication between the parents, and Mr. Sabota stated that he was going to basically take the child because she had deprived him of a few days of parenting time. Is that the essence of the conversation between the parents, Mr. Spiros?
Yes, it is, Your Honor.
Right. The court satisfied that Mr. Sabota is aware of this order. I think that's what prompted him to pick up the minor child from school. That address is not his legal address. The court's informed. Is that correct, Ms. Brower? You have a different address on file?
Yes, we do, Your Honor.
For the record, what is that address?
Street in Toledo, Ohio.
Okay. Did you make a note of that address, Mr. Spiros? Perhaps any order should go probably to both addresses. The front of the court will mail a copy of any order entered by this court to Mr. Sabota at his legal address, the address that he last placed on file with the front of the court. But you may want to make sure a copy of this is sent to him as well at this Garden Estates Apartment 4 address as well. Obviously, the court's concerned that Mr. Sabota is not present. He is not complied with prior to this court. The only option for this court to do is suspend father's parenting time until he petitions the court. That's going to prompt him to appear. I don't know if that's the best interest of the child to suspend dad's parenting time with the holidays coming up. Mr. Spiros, are you asking for any additional relief other than what's being recommended? That the ex parte continue, no overnights for dad, and the child shall not be taken by dad from school?
We're not asking for anything in addition.
All right. All right. All right. The court will currently adopt the recommendation. The ex parte order of November 17th shall continue until further order of the court. Fathers, Mr. Sabota is not permitted to remove the minor child from school. Perhaps you can provide a copy of this order to the school, Mr. Spiros.
Yes.
Does the child go to school at Bedford schools or Toledo schools?
Bedford.
Bedford, okay. And mother's child support obligation is abated as of December 1st, 2023. So hopefully the parties can work out the exchanges. And I don't know about, presumably the front of the court holiday schedule is in place. Hopefully they can work through the holiday for the benefit of the child.
Yes, it's my client's intention to do that.
All right. Anything further than this morning, Mr. Spiros?
No, thank you, Your Honor.
All right, thank you, Ms. Brower. All right, that will conclude this matter. The court will adopt the recommendation. Copy will be mailed out. Okay.
So the 10 o'clock doesn't talk with front of the court system?
I don't know. I just need to review my notes on that. Yes, he was ordered to personally appear.
Right, but I mean, since he's here in person, do they still talk with Emily?
Correct. So you can zoom in, and then when we get done here, you can tell me to zoom in.
And then he can come in here
Yeah,
when we're ready for.
my Zoom ID number is all in the order. So
Okay, so even though your person's still on Zoom.
right.
Gotcha. Page 1, Hazel Meritt versus Martin O'Neill.
For the record, this matter is before the court on the plaintiff's objection to referee recommended order modifying parenting time. This hearing is being conducted via Zoom. The plaintiff, Ms. Meritt, are you present?
I am.
Okay. All right. The plaintiff, Hazel Meritt, is present. In addition, defendant, Father Martin O'Neill is present. The parties have conferred with Ms. Pratt for the front of the court, who has recommended that referee recommended order be rescinded and canceled, inasmuch as father's parenting time is currently reserved per an ex parte order signed November 27, 2023. Child Protective Services are currently involved. There's a court date on the ex parte order on December 12, 2023. In the meantime, the child shall remain at Arborwood South of Monroe Public Schools. I don't see that ex parte order in the court file. What time is that hearing on December 12th, Ms. LaPrade?
Give me just a moment, Your Honor, pull the file back up. It was in
9 a.m.
All right. Right, to Mr. O'Neill, have you received a copy of that order? Mr. O'Neill, have you received a copy of the ex parte order signed on November 27th?
No, I haven't. No.
I'm sorry, you're breaking up. I couldn't hear your response.
No.
No. Is your mailing?
No, I haven't received the, no.
Okay. Ms. Merritt, did you mail a copy of that order to Mr. O'Neill?
My attorney said he's going to be mailing it.
Who's your attorney? I don't see any attorney of record in here.
He's through legal aid. He's the one that filed the motion.
Okay.
I can't
I don't see
minimize
that
this to
here.
pull it up.
Your attorney,
It's Attorney Goldman, Your Honor. There was a
All right.
limited appearance in on base that was put through, and that's only for the ex parte, Your Honor.
all right, so I don't have that in front of me. I don't recall it, but so there's a hearing on December 12th
At 9 a.m., Your Honor.
at 9 a.m. Mr. O'Neill, are you still there?
He was breaking up, so I took the.
Yes.
Okay, so
Yes.
we're going to address the court at this time. We'll rescind the recommended order and we'll discuss these matters on December 12th at 9 a.m.
Can I ask a question?
Yes.
How, let me calm down. How do she have all these violations, not taking Malaysia to school, making false allegations? I have something real important to say. Patrice Patrick has sent the email on November the 21st at 11:46 a.m. Hazel Meritt started her false allegations at 12:12 p.m. She sent the email and everything, was not telling me, but telling my fiance what she was going downtown to file motions on and call CPS on us.
What's your
Because
question,
the
sir? Mr. O'Neill, what's your question? You have an attorney, Jason Kazmarek. What is your question?
how could you grant her that with no evidence, no witness, exactly just like the PPO that you granted?
Right.
I feel like the court's is biased against me. That's what I feel.
I'll have an answer for you on December 12th. The motion is not in the court file, the order. So I can't reference the allegations directly, but obviously there's a verified motion that Ms. Meritt signed this under oath. And so we will address on December 12th. If in fact the allegations are false, then you'll receive makeup parenting time.
No, but I understand, but you treat me like this all the time though. So what I was thinking was, will I be able to move my case to another judge?
Talk with your attorney.
Because I'm tired. She violated so much, and it's like, I don't have no violations. I'm doing what I'm supposed to do. Judge Braunlich, look, this is Miss Meritt. Oh, take my camera out. I have a folder that's big as a dictionary. I have a folder that's big as a dictionary. I have evidence. I have everything. And I don't understand, how do I get the end of the stick when I haven't even did anything?
I understand their allegations right now, and unfortunately, I cannot answer your question, but I can answer that question on December 12th at 9 a.m. So I'll have all the pleadings in front of me.
I don't feel like this is fair at all.
Okay. Well, it's a Child Protective Services involved. Ms. Pratt, does your office verify those things or not always? Does your office receive reports from that agency?
Yes, but look,
Your Honor,
hold on, Mr. O'Neill.
Hold on, Martin. Your Honor, we have not received reports as of yet, but both parties did acknowledge that CPS has contacted them. Mr. O'Neill has spoken with CPS.
All right.
Yes, and she came inside my house and looked at a laser room. Hazel Meritt don't even have a house. She's staying with somebody else. All four of them, three of them is sleeping in the same room. Miss Meritt would not let CPS inside that house where she stays at.
All right. Well, Mr. O'Neill, we're going to get to the bottom of this on December 12th in 2 weeks. December 12th at 9 o'clock. So note that on your calendar and appear on that date, December 12th at 9 a.m. and we'll address the matters. If in fact the allegations are found to be inappropriate, untrue, then the court will award makeup parenting time.
And then,
Your Honor, may I say something, please?
how can I serve her?
No, the court has other
How can
matters
I
made.
serve
We'll
her
deal with this on
anything?
December 12th. Mr. O'Neill, the court was strongly recommending that Mr. Kazmarek back with you, and Ms. Meritt will have her attorney, Mr. Goldman, with them. So we'll address that on December 12th.
I don't need no lawyer for this. I have all evidence that I have.
All right. just a suggestion. The court's going to adopt the recommendation today that the recommended order be rescinded and canceled. We'll discuss all these matters on December 12th at 9 a.m. In the meantime, the child shall continue to attend school at Arborwood South and Monroe Public Schools. All
Is
you
there
both
a
know
way
the copy
that-
of this order.
I really think that you have something against me, Your Honor.
I had nothing.
I really do.
Nothing at all, Mr.
I really
O'Neill.
do. I really do.
Okay.
I have all
Right.
type of evidence. She
Your
don't
Honor,
have
I
no
have a question.
paperwork stating anything.
Present
She don't
that
have-
evidence to the court on December 12th at 9 a.m. Mr. O'Neill
How can
has
I-
nothing against you.
That is so, man. It's
Your
wrong.
Honor, may
I want to hold
may I ask
man,
a question?
That will conclude. Sir, you can both zoom out. You both know the copy of this. We'll see you on December 12th, 9 a.m.
How do
Court has
I
nothing
submit the
against
proof to
Mr.
you?
O'Neill. Ms. Meritt, you can zoom out. That'll
Okay,
conclude
I'm
this
trying
matter.
I'm trying to figure out how do I get all the proof that I have.
Okay, can zoom out, please. Oh, boy. Nancy, I want you to go down and find where the motion order is right now, please. Yeah, you can't do my job and I have no idea what they're talking about.
It was just found Monday.
Okay, can you go down and find it?
I should.
Parenting time, the hearing is being conducted via Zoom. Present is Attorney Alex Goldman, representing the plaintiff mother, Hazel Meritt. Is Miss Meritt present? Oh, there's Miss Meritt. Is Martin O'Neill present on audio?
Yep.
Good morning, Mr. O'Neill. The court would note for the record that this court did enter an ex parte order on November 27th, 2023, which reserved or suspended defendant father's printing time based upon allegations that the 7-year-old child of the parties was being assaulted by children of Mr. O'Neill's from another relationship. In any event, the parties have appeared this morning, have conferred with Mr. Walker for the front of the court. Mr. Walker has provided the following recommendation. The recommendation is that the ex parte order of November 27th, 2023, which suspended dad's printing time, shall continue pending the results of an active CPS investigation and SANE investigation. The SANE investigation is a sexual assault nurse examination. It's further recommended that the parties appear back before his court for review on January 31st, 2024 at 9 a.m. That's the recommendation. Mr. Goldman, is law enforcement involved?
Not to my knowledge. I would defer to Hazel on that. Miss Merritt, do you know if law enforcement has gotten involved with this?
Yes, they have been involved.
What, Michigan State Police, Monroe County Sheriff's Department?
It's the Monroe County Detectives Bureau is involved.
Okay, Monroe County Sheriff's Office. Right, Mr. Goldman, is this recommendation agreeable with your client? Presumably it is, correct?
That's correct, Your Honor. We agree.
Okay. What about some FaceTime?
No, I mean, I'm not doing none of that because none of this is true. None of this is true, man. None of this is true. She is a liar. Look your client up, man. Look your client up. She been lying to detectives and all. Look your client up. This is not true.
Your Honor, I attempted to get some type of
this over a child. She violated her.
And Mr. O'Neill did not want to do that.
Mr. O'Neill, we're going to mute because I cannot hear anyone else when you are yelling at the court. So we're going to mute you, and we will unmute you when we have a chance to talk. Obviously, you are opposed to this recommendation. Mr. Walker?
Your Honor, in the breakout room, I did attempt to facilitate some type of interim parenting time. Mr. Goldman was okay with that and would have allowed some type of parenting time. Mr. O'Neill refused to talk about parenting time.
In terms of supervised parenting time?
Mr. Goldman, supervised or unsupervised, either one was, both were brought up, and Mr. O'Neill refused to discuss parenting time.
Okay. Obviously, other than the allegations of Mr. Goldman, we have no documentation. Do you have some reports?
I've done everything I can to procure those, Your Honor. I did submit a request for records using U of M's HIPAA authorized form. I sent that to them. I let them know about the urgent nature of this request to get it expedited, and I haven't gotten that back. I've left a voicemail for the CPS worker. She hasn't returned it. I think the results of that SANE exam from U of M are going to be the most probative information for the court, and I believe I've done all I can to request it.
Of course, that was done on November 25th, and the court has no documentation. So all I've got is, mother's allegations.
That's correct, Your Honor. And I'm doing everything I can to get information that will confirm or deny that. We aren't trying to deny all of Mr. O'Neill's parenting time. We are willing to allow some unsupervised parenting time as long as it's not in that home. I just think that while we're waiting for the outcome of these dispositive investigations, that it's prudent to proceed with caution.
Okay. So Mr. Walker, the court would like a recommendation regarding a parenting time for dad in the interim. Again, there's other than allegations. The court does not want to simply deny dad parenting time. And if Mr. O'Neill chooses not to exercise that, then so be it. Okay, we'll unmute Mr. O'Neill. Mr. O'Neill, the court has a question for you. The court wants to reinstate your parenting time. Mr. O'Neill, can you hear the court?
Yes, I can.
Okay, the court wants to reinstate your parenting time. These are allegations. The court agrees the court is not satisfied that there's proof of these allegations. But so the court wants to order some parenting time. We'll come back in January, hopefully with some documentation. If not, we're going to throw all this out. But in the meantime, we have holidays coming up. I want you to have parenting time with your daughter. Just want to make sure that it's a good. Hold on, just a minute, please. Let me finish. We want it to be in a safe environment. So the allegations, the home in which you reside, does your 13-year-old and the 20-year-old reside in the same home?
No. He's 22 years old. He haven't been here ever since he graduated out of high school. She don't even know what she's talking about. She thinks she know whatever. She thinks she know what goes on in my house, and she don't.
Mr. O'Neill. The
lawyer report and the CPS report does not match up.
Mr. O'Neill, will you listen to the court? Do those children live in the same house that you live in?
No, they don't. My 13-year-old son, though.
We're going to talk about some parenting time, Mr. O'Neill, which the children are not there, so it's just you and your daughter.
I'm not. No, because all these allegations are lies. If you put a lie detector under her, it's going to ring off. I'm not backing down for nothing.
Mr. O'Neill, do you want to see your daughter over the holidays?
I want her inside my house. I don't want to be going to McDonald's or to no library or none of that.
That's fine.
We haven't, nobody did anything to Elijah here.
Mr. O'Neill, will you stop arguing with the court? I'm just trying to get through this.
I'm not arguing with the court. It seems like y'all biased against me again. And y'all got all type of reports.
Which other children should not be present?
Then no. Nope.
Mr. Walker, what was your suggestion to Mr. O'Neill, that the children not be present or there be a supervisor?
Man, his paperwork doesn't even match up with the CPS paperwork.
We're going to mute Mr. O'Neill once again. Mr. O'Neill, you are being disruptive, and you will not, if you will not listen to anyone. Mr. Walker, what's your recommendation in terms of parenting time over the holidays? That be supervised, or that these children, Mr. O'Neill's a 13-year-old, I don't know what their names are, but it's alleged a 13-year-old allegedly assaulted a child with a knife. I don't know why police were not called at that time. So the court has a hard time believing these allegations, Mr. Goldman. If the police were not called when this 13-year-old son of Mr. Goldman allegedly assaulted the daughter with a knife, really? Police were not called? Okay, then there's the other allegation of 20-year-old that sexually assaulted the child. Again, Mr. Walker, what's your what do you find to recommend?
Your Honor, I was unable to even talk about a possible recommendation with Mr. O'Neill because he would constantly interrupt me, and I was not able to get a word out edgewise. However, I would make a recommendation that he get to at least spend some time either Christmas Day or Christmas Eve for a few hours without anybody else in the house.
All right. Prior to this court's expiry, Mr. O'Neill's parenting time, if the court recalls, was week on, week off. Is that correct, Mr. Goldman?
I apologize, Your Honor. Can you repeat that?
The current order of this court is week on, week off parenting time. Is that correct?
That is correct.
All right.
The police are involved in this.
There's no documentation that this court has, Ms. Meritt. These are simply allegations.
I contacted the police hang on a second, my baby's crying. No, Kiki. Sorry.
We're gonna let your attorney talk, Ms. Meritt. We're gonna mute you because we cannot hear when you got a child. You're in court right now, and we've got a child crying right now. We cannot conduct this. All right. Here's what the court's gonna do, Mr. Neal. The court's gonna reinstate your parenting time, provided that the Martin O'Neill Jr.
Your Honor, the police are involved. I have a police report number and everything.
Hazel.
Okay. The court's going to reinstate Mr. O'Neill's parenting time with the understanding that Mr. O'Neill's children will not be present. Mr. O'Neill's children from another relationship are not present. Okay, we'll unmute Mr. O'Neill. Mr. O'Neill, do you understand the recommendation? Mr. O'Neill?
Here I come.
You want
No,
just stop 1 minute and listen to the court. Yeah, the court is willing to reinstate your parenting time week on, week off, provided that your son Martin, your daughter Alexa, and your daughter Carrie are not present. Can you comply with that, such an order?
No, I can't, because they love their sister. They have not did anything to their sister wrong. Nothing at all. All this stuff is all lies, and it's just lies.
Right. Trying to make it work, Mr. O'Neill.
Yes,
all right,
sir.
So what the court's going to do is the court will continue the ex parte order. We're going to send this for a review sometime later this month. Mr. O'Neill, when you come back with documentation, we're going to.
Can I say something else, please? Just one more thing.
Hold on just a minute, Mr. O'Neill. Can you put on December 20th, the 21st?
The 20th, sir, at 2:45.
Okay, we're going to put this over to December 20th. Ex parte order will continue. We'll put this over to December 20th at 2:45 p.m. And Mr. Goldman, the court's going to want documentation. You need to have a detective here that's investigating the case, speak to that person, or we need some documentation. We need proof of these allegations.
Understood, Your Honor.
So, Mr. O'Neill, the court's going to adjourn this matter for 1 week. We're going to put this on our docket December 20th at 2:45, so we can get the bottom of this. Right, Mr. O'Neill, you want to say something else?
Yes, can I please? Because I have to get this out. I have got his report, the lawyer report, and I have got the CPS report. They don't even match. It don't even match. It says that she was cut. It said that she was cut with a knife or whatever. Why the police wasn't called? And then the 19th was the last time that I seen Elijah. Why did it take her all the way to the 25th to take Elijah to the emergency room? And then where's the nurse report? This man sent me all these type of reports, but except the nurse report. He didn't send me the nurse report, and his paperwork do not matches up with the CPS paperwork.
Right, Mr. O'Neill, provide a copy of those reports to the court and to Mr. Goldman.
I sure will.
So you deliver them up to the court up here, and then the court will have reviewed those, and we will discuss this matter further on December 20th at 2:45.
And I feel like my daughter is being molested wherever she at. That's what I feel like, and I feel like that I need some type of address or something where she stays so I can send CPS to her house, like she did mine. Tick for tack. It's not fair. It's not fair that y'all put Kari Phoenix in here and he haven't been in the home ever since he graduated out of high school in 2020. That don't even make sense. And she's never alone with the kids. Never.
All right, Mr. O'Neill.
And that's court order.
Reports, Mr. O'Neill. Provide copies of reports to the court and to Mr. Goldman. Make a note, because we'll get a notice out today, but it's pretty quick continuance. So we're going to review this matter December 20th at 2:45 via Zoom. And Mr. O'Neill, you may want to talk to Trent, because you are shooting yourself in the foot, because when you don't listen to parties, you are working against yourself. I'm letting you know that right now.
They lying on my family, but I can't protect my family.
All right. All right, Mr. Walker will advise the recommendation.
Yes, I got
That's
thought.
right. We'll continue until December 20th at 2:45. And hold on, Mr. Neal, we got one other matter we're going to deal with this morning, which is the alleged PPO violation. Mr. Goldman, are you involved in that? It's a show cause initiated
No,
by
Your Honor.
Hazel Meritt.
My limited scope representation only covers the ex parte and related hearings.
All right. Okay, well, Ms. Meritt, you stand on the Polycom, and Mr. O'Neill, you're still there, correct?
Yeah.
So,
All right,
Your
all
Honor,
right,
I'm
Mr. Goldman,
excused.
thank you. You can zoom out, Mr. Goldman. We'll see you next week.
Thank you, Your Honor.
Which Hazel Meritt filed a motion for to show cause alleging that Martin O'Neill violated personal protection order of this court. Both parties are present via Zoom. Ms. Meritt, you've alleged that you're in the referee room when Mr. Meritt said you are a liar with your stinking ass. He told me that I falsified our daughter's doctor's notes, just like the order that was signed on November 27, 2023 is fake. That's your
Correct.
allegation? That's
Yes,
your allegation, is that correct?
that is correct.
And how does that violate the personal protection order entered by this court?
Because you placed it that he's not allowed to confront me in public. He's not allowed to say anything to me. And when he's addressing me and calling me names, that's violating the PPO. He seems to think it's okay to constantly call me names, constantly lie on me.
Lie. Wow.
All right. Obviously, Mr. O'Neill, it's childish. It's childish. I mean, come on. You're a parent. You're gonna
Childish, she
call other
lying
people
on my
names?
family. I never called her stinking. I said it stink in here. That's what I said.
No,
And
you
the
did
ref
not.
can vouch for that.
All
No.
right, the court does not find this allegation to violate the personal protection order. Ms. Merritt, it prohibits Mr. O'Neill from assaulting you, threatening you with physical harm or violence, interfering with your employment, following you,
Like,
confronting you in a public place. If he comes up to you in the store, is in your face, that's one thing. But during the friendly court referee hearing, he makes inappropriate comments. The court does not find it to be in violation of the personal protection order. The court will accordingly dismiss the violation. All right, that will conclude this matter. We'll see you both next Wednesday, December 20th at 2:45 p.m. on parenting time.
Yep, and I had that paperwork for you.
you said what, Your Honor? I apologize. My computer cut out.
The court finds the allegation does not violate the personal protection order. The court is only dismissing the show cause. I'm just asking that Mr. O'Neill act as an adult in the future. All right, that will conclude the matter. You can both zoom out. We'll see you next week, December 20th at 2:45.
Court is now in session, middle of page 2, Sarah Perkins versus James Wentworth.
For the record, this matter is before the court on the objections filed by defendant James Wentworth to a recommended order. The referee of October 25, as well as objections to recommend order of November 7th, 2023. This hearing is being conducted via Zoom. Ms. Plaintiff Mother Sarah Perkins present. Mr. Wentworth, are you present? James Wentworth?
Yes, I am.
All right, good morning. The two of you have conferred with Ms. Brawlers for the front of the court. Ms. Brawlers recommending that the referee recommended order. There are apparently two recommended orders, Ms. Brawler. I can only find the recommended order of November 7th, which did not deny the plaintiff's motion to modify custody. Was there also a recommended order of October 25?
Yes, that was a referee's recommendation for a bench warrant. Mr. Wentworth failed to appear at a show cause hearing with referee McKee.
Okay, all right. So we're dealing with both of those then today. The recommended order this morning, Ms. Perkins, Mr. Wentworth, is that the recommended order be adopted but modified. Namely, both of you shall complete a high conflict solutions workshop. It's online. We'll provide you with the website, and you should submit a 100-word essay to the court of what you learned from that program. You need to start co-parenting. So the court believes this program will assist you in dealing with the other parent for the benefit of your child. So you should both shall complete that before we come back to court. The minor child, Colton, shall take all medications prescribed by his physician. And you need to communicate with each other regarding those prescribed medications and make sure the medications are passed to the other parent during the other parent's parenting time. Minor child Colton shall continue his education at Edgemont Elementary School through Van Buren Schools. all appointments scheduled and or canceled for Colton must be added to the app close calendar within 1 hour. It's noted that the two of you had a parenting time show cause before referee Hamrick yesterday. Ms. Hamrick referred that issue to the court today to be addressed today. So this order today addresses all parenting time complaints filed prior to today.
Your Honor, may I say something?
Just one moment. Ms. Perkins, do you understand the recommendation?
Yes, I do.
Okay. Do you have any objection to the court adopting this recommendation?
No, I agree with it, that we need to.
Need to what?
That we need to communicate better and.
Absolutely. All right. And of course, your motion to change custody, by Michigan law, there needs to be a significant change of circumstances to warrant even a hearing to modify parenting time or custody. The two of you have joint legal, sole physical to the plaintiff mother. So you need to share information regarding Cole's medical situation as a joint legal. All right, Mr. Wentworth, do you understand the recommendation, first of all?
Yes, I do, Your Honor.
Okay, do you have an objection to the court adopting this recommendation?
Well, Your Honor, over the summer months and into the beginning of the school year, I was exercising my parenting time every weekend from Friday until Monday morning, and I'm asking that the courts allow me to resume that custody time. I will take Colton to school Monday morning, as well as pick him up from school Friday afternoon. I will attend any other communication classes that the courts would recommend. And with this being said, me picking Colton up from school on Friday and taking him to school on Monday would not require Sarah to do any driving. And I'm also asking that the courts allow 2 phone calls throughout the week, because Sarah is currently preventing any means of communication between me and my son and my family and my son.
Did you discuss that with Ms. Brower this morning?
I didn't get a chance.
Okay. I mean, the FaceTime phone calls are not unreasonable, but are you asking to modify parenting time? Where does Colton go to school right now?
As I said, he goes to Edgemont Elementary, and over the summer months, I had primary custody of Colton, and I'm just asking that I be allowed to resume that custody.
Okay, this order does not change any custody. It's joint legal physical to mom. Now, parenting time, if I recall, is dad's parenting time is every Sunday. Maybe that was an order of November of 2022. Sundays 2 to 7, supervised by the paternal grandfather. What is your current parenting time, Mr. Wentworth?
That's my current parenting time. Is I pick Colton up from school on Friday, and I meet Sarah at the Milan police station on Sunday, 3 weekends a month. But I'm asking that the courts allow me to have Colton every weekend. From Friday, I will pick him up from school, and then I will take him to school on Monday morning. That way Sarah doesn't have to drive. It's not requiring her to do anything, and it is allowing me a little bit more time with my son, because he's really struggling with the exchanges.
Well, I do see that in the order of December 2022 indicates fellowship parenting time the first, second, and fourth weekend of the month from Friday at 6 to Sunday at 6. Exchange at the Milan Police Department.
No, the order we're following right now is I pick Colton up from school on Friday, and I meet Sarah on Sunday, the first, second, and fourth weekend.
Okay, and I didn't realize parenting time was an issue before the court this morning. So I wasn't prepared to deal with parenting time. Ms. Brower, did the front court referee address parenting time? Was that one of the motions followed by Mr. Wentworth to modify parenting time?
No, his motion was a change of custody.
It was a misunderstanding.
He was asking for full custody of the child.
Okay. Well, that, again, to the extent that I guess you both filed motions for change of custody, there needs to be a significant change of circumstance in order to modify or consider modification of custody, Mr. Wentworth, because the Child Custody Act does not, they want stability in the child's life, and the child's not being just back and forth like a ping pong ball. So you need to file a motion to modify parenting time if you want to modify parenting time.
That's right.
You and Ms. Perkins can work something out in terms of the pickups and drop-offs. That's great. But it appears right now from the court file that your parenting time is Friday at 6 to Sunday at 6. Yeah, it makes sense if you can agree that you pick up the child. You basically want to pick up Colton from school on Fridays, correct? On your weekends?
That's my court order right now, is that I pick him up from school on Friday. And there's been a serious lack of communication, but I have provided documentation that I did in fact have Colton in my custody for a majority of the summer. And all I'm asking is that I be allowed to have him I'll pick him up from school on Friday, which is already in place right now. And he's really struggling with the exchange. So I'm only asking that I take him to school on Monday morning.
Okay, well, if it's already in the court order, I'm not sure what you were asking.
Like I said, it was a misunderstanding. The custody, I thought that was like the time that Colton was with me, because as I stated, he spent a majority of the summer in my custody, and Sarah and I were co-parenting great. And that has since completely stopped, and Sarah's refusing to communicate with me, as well as preventing any means of communication between me and Colton when Sarah has him.
It appears that the court entered an order setting a hearing for October 3rd. Okay, yes, the last order of this court, Mr. Wentworth, October 3rd, 2023. Your parenting time was modified, so you have parenting time the first, second, and fourth weekend of the months, Friday from school until Sunday, 6 p.m.
That's correct.
Ms. Perkins is not recognizing that order. She's not following it. Is that what you're suggesting?
Well, the last time we came before the courts, you made it very clear that I should be allowed to speak to Colton, because, I mean, a healthy communication is definitely a crucial part of Colton's life. And
hang on. Let's go back. Right now, are you picking him up from school on those Fridays?
Yes.
All right. So that's already in the court order, Ms. Perkins. On the first, second, and fourth weekend, Mr. Wentworth, Dad picks up Colton from school on Fridays, those Fridays. Do you understand that?
It has been that way since it's been ordered.
Okay. So I'm not sure what your concern is, Mr. Wentworth. I'm a little confused. Do you want to be able to talk with them in the meantime, FaceTime during the week?
Well, with Sarah having Colton on the third weekend, with the holiday schedule conflicted with that. So with that being said, I did not have Colton the third weekend, and then Thanksgiving came right after that. So I have not spoken to my son in almost 3 weeks because Sarah's preventing any communications, and I need that changed.
So what are you asking? Are you asking that you have FaceTime with them?
Well, I would, like I said, I'm asking that I pick Colton up from school on Friday, and I have them.
You already got that. Now,
yes,
and the
every weekend though.
Fridays of the month. Hold on, 3 Fridays of the month. You pick them up from school. It's already in the court order.
Yes, so I would like him every weekend of the month, the 4 weekends.
Oh, well, you got to file a motion to modify parenting time. Again, unless Ms. Perkins is agreeable to that this morning, your parenting time, we just dealt with that. So you need to show what has changed since October that you want every weekend. But again, it's reasonable to have some phone contact. Does Colton have a phone, Ms. Perkins?
He does not. He's 7 years old.
Oh, 7. Okay, I'm sorry. I thought he was. I dealt with another Colton earlier today, and it was 13. Any reason why you can't facilitate FaceTime between Colton and his dad during the week?
To be completely honest, every time that I have tried to let that happen, it starts off very well in the beginning of him talking to Colton, and then it's directly towards me where he'll say, you know, Colton, I miss you. How are you doing? I'm so sorry your mom doesn't let you see me. And then that's when I take him off.
Mr. Wentworth, if that's happening, that's inappropriate. Your conversation with your son deals with you and your son. You do not mention anything about mother.
That hasn't happened.
You're creating issues for your son, Mr. Wentworth. So at this point in time, the court's not going to modify parenting time without you filing a motion and notice it on for hearing.
Well, I will do that today because I thought that's what we were here for today. And what Sarah just said is untrue. And I provided proof that she hasn't allowed me any phone calls or anything. So how could I possibly do that?
Okay. Well, so what the court wants you to do before you file that motion, I want you to complete this high conflict solutions workshop.
Okay. And I have completed the SMILE program as requested, but apparently there was some issue where you guys have not received that confirmation. But I did, in fact, do the SMILE program, and I submitted my answers to the questions to the front of the court.
Okay. Again, obviously, not benefit from the SMILE program. That's why we're elevating this to the high conflict solutions workshop. These are for parents that simply cannot co-parent their child. So take that class. Hopefully you'll benefit from that and then file your motion. All right. So the court will adopt the recommendation of Ms. Brawler this morning for the further court, you'll both know the copy of this. Plenty time will continue as previously ordered. Hopefully you can enjoy a good holiday with the child. The simple things are really important. Mom, you should make sure that, well, your child's 3, he's probably too young, but
He's 7.
7. I mean, so he's old enough. Make sure he gets something for his dad for Christmas. Dad, you make sure that Colin gets something for his mom for Christmas. That means a lot. It's a significance to the child that the other parent respects the other parent. Just a suggestion. It's a good thing to do for your child. You take your child shopping and to get something for the other parent. So in any event, with that having been said, the court will adopt the recommendation. You both know the copy of this and try to have a good holiday for the benefit of Colton. All right, they can zoom out.
Your Honor, there is a second matter with these parties. The issue of the recommendation for a bench warrant.
Okay, to receive another order, and Mr. Wentworth, that the recommended order be of October 25 be rescinded and canceled. The show cause is adjourned to January 16th, 2024 at 8 a.m. via Zoom. Any questions, Mr. Wentworth?
No, Your Honor.
All right, so no bench warrant will issue, and just make sure you appear on January 16th and make your any support payments in the interim. All right, that will conclude this matter.
Yeah.
Okay, Ms. Barr, all right, for the record, we'll call the case.
Michaela Drulick versus Curtis Carson Jr.
For the record, Mr. Carson is appearing from the Monroe County Jail, having been arrested on a bench warrant. Also present for the Zoom hearing is Monroe County in front of the court attorney, Rebecca Hicks. Bench warrant has been canceled, Ms. Hicks. Can you provide some information regarding Mr. Carson, please?
Certainly, Your Honor. In this matter, there is a current monthly support obligation of $415 per month. The current balance is $2,864.87. We do have a previous finding of contempt on Mr. Carson. It is from September 15th of 2016. It is a first finding, and there is a 26-day balance.
When did Mr. Carson last make a payment?
We did receive a payment earlier this month on November 22nd from, it looks like Aggressive Hiring, from an income withholding notice.
Okay.
And they just took money out of my check this week too.
Okay. You were mailed a notice to appear for review, Mr. Carson. You failed to appear for review.
Well, I didn't understand why they was sending me anything, because me and my child's mother had went down to the front of court together and to take me off child support. They said that they took me off, and I don't understand how I'm back on child support because we went down there together.
Just because she told you that, I mean, you need to verify those things yourself.
No, we went down there together. I've seen it.
Right.
They did. They left me alone for a couple months, and then all of a sudden I'm back on it. I don't understand how.
Your Honor,
Ms. Hicks?
For the record, the other party came in April of this year and filled out an affidavit to waive all the arrears that were owed to her, and we pulled the bench warrant that he had at that time. Since then, he has had another bench warrant. He was arrested on it in July and posted a $500 cash bond, which we then forfeited towards the arrears and set the adjourned hearing date for September 12th, which is when he failed to appear, and this bench warrant resulted. So that's the only other thing we have in here. Was back in April of this year, she waived the arrears that were owed to her.
So these arrears are due to the state of Michigan, is that correct?
Well, no, support in this matter never stopped. So once she waived arrears that were owed to her at that time, new charges have accumulated every month. So there's a current monthly support obligation of $415 a month. So now there's additional arrears that are owed to her, as well as, yes, some arrears that are owed to the state. They never stopped the support obligation in this case, Your Honor. There is a current support obligation of $415 per month in this case.
All right. Thank you, Ms. Hicks, for the explanation. Ms. Carson, you understand that even though she waived arrears as of April, it went down to zero, you still clicked along at $415 a month. That support order was never stopped.
I don't know where I'm sorry.
You understand?
I guess I was misunderstood.
You understand you got arrears of $2,800, $2,800 because you're not paid anything until just recently. And it's been clicking along, increased by $4 a month from and after April. So if you want, you can call her. If she wants to come down and waive the arrears to her, that might help you today.
Well, yeah, we're trying to get it to where like me and her just do it without the courts. That's what we thought we did the first time.
Right, she can waive emergence due to her. If the child's not on public assistance, Mr. Carson, you need to file a motion to reduce your support obligation or to stop it and see what the response is. You need to take the affirmative action. You can pick up a form for the front of the court, a motion to modify support, file that, and ask the court to stop your support obligation. And that's your obligation. It's not Ms. Droulard's responsibility.
I understand that, sir. We thought that that's what we were doing the first time. I'm sorry.
Well, that did, but you were able to notice it. If you get a notice, you should call and say, hey, I thought this was all done. Why are you sending me these notices? The front of the court would explain to you, okay, it did get zeroed out, but it's still clicking along at $4.15 a month.
Okay.
So
yeah. I just talked to her.
Before midnight or after midnight?
It was after midnight last night.
Okay. Okay. Are you currently employed?
Yes, I am. They currently just emailed me. I mean, they currently just mailed me something to my house, letting me know that they're taking money out of my checks now.
Right. With whom are you employed?
The Hungry Howie's in Ann Arbor.
Is that full time?
Yeah. Well, it's weird hours. Like I can work 6 hours one day and I can work 9 hours one day. Like Friday and Saturday, I'm working from like 4 to 1 to close.
All right. Ms. Six, do you have any questions for Mr. Carson?
I do not, Your Honor.
What's your recommendation? Obviously, the court would like to see Mr. Carson get back to work. Mr. Carson, you need to do a couple things. Number one, you got to have Mr. Lord come down and waive his rearages. If you're not, then you got $2,800. And right now it's every month add another $415. You understand that now?
Yeah, she will. She will. I talked to her about it already. The only reason why we haven't came back is she got COVID right now.
Is your child on public assistance?
I don't think he is. I don't think so.
Insurance, health insurance, because if he is, then she cannot waive rearages due to the state admission, waive rearages that are due to her. Ms. Six, are you able to tell whether or not this child is receiving public assistance?
I am not on that screen now, Your Honor. I don't believe that they are. It doesn't look like any of the medical support is owed to the state. I believe that all of this is being owed to the mother for the majority. So at this time, Your Honor, the front of the court would not be opposed to just 1 day immediate credit for the 1 day he has served, release him so that he can get back to work, but do a very short adjournment. So requiring that either he and Ms. Drouillard come in together, or schedule an agreed upon hearing, or that he files a motion to modify their support or makes payments on this case in the interim.
Okay, what adjourn date do you recommend?
I would recommend January 9th at 3 p.m.
All right, Mr. Carson, here's what the court's going to do. The court's going to order you to serve 1 day in county jail. Give you credit for the 1 day you've served. So you got 25 days to have your head. The court's going to release you on a personal bond. You'll be processed released today. You order to appear before Ms. Six for review January 9th, 2024 at 3 p.m.
Okay.
Okay, you need to appear one way or another. So either, hopefully, Mr. Lawrence waived the rearages, but you need to take the step of filing a motion to reduce your support or stop it, one or the other.
Yes, sir.
Or waiving the rearage, it's going to go down to zero, but it's going to stop popping up at $400 a month. You need to take the steps. Keep in contact with the front of the court. When you ignore these matters, Mr. Carson, that's why you end up in jail. The court hopefully wants you to keep that job. So we're going to release you today, and you need to appear January 9th at 3 p.m. Come over to the courthouse. When you get released from jail, pick up a copy of a form, motion to modify support. They give you a form. You just fill out the blanks.
Yes, sir.
And get Mr. Drouillard down here to see if he lets you waive the rearages. If he doesn't, you got almost 3,000 arrears. You need to take some action. All right. Do you have any questions, Mr. Carson?
No, sir.
The copies will be mailed out to the address you provided. Also, a copy will be faxed over to the jail. You'll get a copy of this when you're released today.
All right.
All right. You can step out, Mr. Carson.